You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
Welcome back to the podcast where we break down the workers' compensation system one practical lesson at a time. I'm your host and favorite defense attorney, Nasir F. Adil. In this episode, we're joined by experienced AMA Guides Analysis and Ratings Department raters, Alex, Sadek, and David Roman, who collectively have reviewed thousands upon thousands of medical reports. They take us behind the curtain to explore what they look for when a report lands on their desk, the common mistakes doctors make, and why a simple mathematical error can completely change the value of a case. We'll discuss everything from range of motion calculations and DRE classifications to the surprising number of reports that contain errors. In fact, you may be shocked to learn how often even experienced physicians miscalculate impairment ratings. If you've ever assumed that a doctor's final number is automatically correct, this episode may very well change your perspective. We'll also explore why well-written reports are worth their absolute weight in gold, how defense attorneys can identify weaknesses in medical opinions, and what separates substantial medical evidence from conclusions that simply don't hold up under scrutiny. And don't worry, we promise not to spend the entire episode debating shoulder flexion measurements, although after today's discussion, you might find yourself double-checking them anyway. Whether you're a claims professional, attorney, hearing rep, or simply someone interested in the mechanics behind workers' compensation disability ratings, this episode offers valuable insights into one of the most important and often misunderstood parts of the claims process. Let's dive in. Today's episode applies for CE credit. In the show notes, you can also find the link to the CE credit form or send an email to compcorner@bradfordbarthel.com for a link to the CE credit. Please be sure to email your Comp Corner questions to compcorner@bradfordbarthel.com. Our email is in the show notes below. All right, a Comp Corner thank you for our CE episode featuring our AMA Guides Analysis and Ratings Department. We are lucky enough to have Ms. Alex Sadek, Certified Impairment Rater, and Mr. David Roman, Ratings Specialist with Bradford and Barthel. Thank you both. How are you both doing?
We're good. I'm good.
Hello. Yes, good to be here.
I'm excited to have you on as your experience with doctor reports and permanent disability ratings really get to the heart of what our audience and frankly what I deal with every day, not only with medical legal reports, but also with regards to discovery and of course, ultimate settlement of claim. So I wanted to kind of start with asking you a question that I'm curious because, when I look at a report, I know where I look at a report often, right? When a defense attorney gets a report, most likely a medical legal report, we look at, hey, are they permanent stationary? What's the diagnoses, right? If they're permanent stationary, what's the impairment? What's the apportionment? What's the restrictions? What's the future medical care? If they're not permanent stationary, fine. What's the recommended treatment in order for them to be permanent stationary? So, Alex, from a rater's perspective, where do you start when you work on a rating? For example, what part of the report do you review first, or what's the first step you take personally?
I tend to jump straight to the discussion with an overview of the discussion. I find, or I hope, I should say, that the doctor has done a decent job of summarizing the mechanism of injury, because that's really important for us.
Sure.
Some of the treatment, and then going into the impairment analysis. That's where I start. But as soon as I'm done with that section, I'm jumping to the physical exam findings, because that is where we're going to get the bulk of our objective findings. And those are very, very important to us. Yeah. What we do is reading those objective findings and translating them into impairment.
No, thank you, Alex. How about you, David? Where do you kind of jump to initially when you first perform a review for rating purposes?
I think that my approach is quite similar to Alex's. I will start off with the introductory part where the doctor will talk about the history of injury and treatment, and hopefully the doctor will uh, give good information to sort of help uh, make it a narrative journey to tell a story that takes us through the physical findings. And then hopefully those are going to support, ideally, what's supposed to happen is those are to support the impairment conclusions given by the doctor at the end. I may hop to the end now and again, though, and look at those and then work back from there to say, okay, the doctor came up with this number. How did he come up with this number? Let's go back to the physical findings for each body part. I'll tend to go head to toe, or usually work with the spine and then do head to toe from there if there are multiple body parts to be addressed. But then just hop back and forth between the doctor's conclusions and the physical findings to see if they're uh, supported, consistent with the conclusion.
Now, I think you both gave very, very good answers. And I think, often as defense attorneys, I preface with we go to whether they're permanent and stationary or not. Then we go to whether, diagnoses, we go to impairment, et cetera. But none of that is relevant unless if the physical examination findings and objective findings are properly, if whether they properly constitute substantial medical evidence. So what I mean by that is from a defense attorney perspective, let's say you have a very applicant friendly doctor who wants to give DRE super high or range of motion super high or Almaraz Guzman super high. Fine. They want to give the applicant a very high rating. But the best way to kind of cross-examine them or show a trial judge, hey, the report isn't worth that high of a rating is going back and saying, hey, doctor, the physical examination findings show very minor results. The objective findings do not show anywhere near the level of impairment you're trying to give. Guess what? If you can cross-examine the doctor on that, or at least show that that report's not substantial medical evidence, then you've really provided a crack in the armor that the doctor's trying to support. So I'm really glad that you both mentioned how that's a really important part of the overall medical process and getting the doctor's opinion to be actual substantial medical evidence or not. So, David, what are the most common errors you see in the reports you rate?
I think the most common errors are when a doctor is asked to or is determining range of motion loss as a as a as a method of assessment for a joint, whether it be upper extremity or lower extremity. These there are instructions, the AMA guides as to how to take measurements. Sometimes the mistakes are made in how the measurements are performed, or whether they're done sufficiently to be considered repeatable and therefore rateable. But more commonly, what we see are mistranslations of the impairment values assigned within the AMA guides for that joint, for that plane of motion when it's measured. Having rated as many reports as I have now at B&B and in my prior life with as a hearing representative and rater in the applicant's realm, it's come to my attention how frequently the doctors will miscalculate or mistranslate information in terms of the value for the range of motion loss in a shoulder or an elbow, a wrist, a knee, etc.
And David, how many reports have you rated? Can you give us an estimate?
Well, they say if you put 10,000 hours in at something, you're good. I would not be surprised if I've hit the 10,000 mark over the course of my career since 1991. Wow.
So, just a rough estimate. We don't want to always focus on the errors that doctors commit, but let's, while we're on this topic, how many of those reports would you estimate or give us an approximation as to how many have errors in those reports, whether it's range of motion loss, measurements, or miscalculations?
When a doctor is assessing range of motion in a joint, I would say 25% of the time.
That's fascinating. That high. Yeah. That's fascinating. I mean, that just goes to show the importance of really going through the report and making sure that the calculations are given. And look, that means 75% of the time they're probably correct or close to correct, but 25 is a big enough number where you got to really make sure you review the measurements. You can't just take what the doctor's calculating to be gold.
Mhm.
So now that's excellent, David. Thank you
Yes,
for
and
that.
in the course of your practice, when you go to the DEU for a consultative rating, you may observe how often
Mm.
that the disability evaluator will be making corrections. We do the same thing. They recognize corrections, they make them, and they do not take at face value simply what number the doctor assigned. They go and look at those measurements, and they look at the AMA guides, and they make those corrections. And if you've put a lot of reports before DEU raters for consultatives or summary rating determinations, you may frequently encounter that, and they'll explain, as we do in our analyses, why they've made those changes.
And I'm glad you brought that up. And maybe it's just the Bay Area WCABs, but I've noticed the last 5-10 years, especially prior to that, not so much. The DEU raters will actually point out errors and miscalculations more than they ever did before. They don't just take, hey, this is what the doctor says, so here's just the straight rating based on the black and white ink that the doctor's stating. They'll actually put their own analysis in, which is helpful because that's what the judges see, right? So when the judge sees that, he or she will be like, oh, well, the doctor's report, maybe it's not as strong as the doctor's trying to say it is. So I'm glad you pointed that out. Thank you for that. How about you, Alex? What are some common errors you see in the reports that you rate?
Um, Transposing numbers. I see it all the time.
Mm, interesting.
You'll see in my reports that I always calculate off of the physical exam findings, not what the doctor has listed in the discussion,
Mm,
because it's so often to flip the flexion and extension measurements, or to flip internal and external rotations. So I always rely on what's in the physical exam findings. And I did a report the other day, and what was in the physical exam findings was not at all similar to what was in
wow.
the discussion. And so I had to point out, I don't know which one of these is actually what the applicant performed at. I can't tell. They're that different. And so that was something that I had to just come to grips with. I don't know. I wasn't there.
Right.
So here it is based on the physical exam findings, and here it is based on the discussion findings.
Yeah. And I'm glad you pointed that out because if you can't tell that, then the attorneys or the claims are going to have different ratings as well. And that might just be a situation where you have to ask the PQME or AME or treating doctor to provide a supplemental, really fixing or maybe asking them to readdress their own conclusions and base, hey, say, doctor, look, your physical examination findings were X, but your conclusions were Y. Can you please explain that discrepancy? The reason why that's important is because then you can actually have a report that's substantial medical evidence. Because if the ratings are off because one party relies on the physical exam findings while the other one applies whatever the doctor's concluded, then the judge will not have substantial reporting to really provide their rating until the doctor clarifies that. So I'm glad you pointed that out. Thank you, Alex. Now, David, what type of injuries are most frequently given incorrect impairment by doctors, in your opinion?
I think the ones that are most frequently given incorrect impairment are the ones that are most that we see the most of, and I
For
think that
sure. Yeah.
the spine region
Yeah.
is where a vast majority of injuries, physical injuries, uh, come up in the
Sure.
reports we receive. There are a couple methods of assessment for spinal injury. One is preferred over the other, that being the DRE method,
Mhm.
and the lesser preferred method is range of motion. Um, the DRE method is relatively straightforward. There's a set of criteria that establish certain classes of impairment that have values you can assign within that class. Um, there can be when a doctor utilizes the DRE method, there can often, very often, be overvaluing
Uh,
because the doctor arrives at a number and within a class that is not supported by the criteria that the AMA guides spell out for an injury of that type. Um, you to just to give a brief example, very technical example though, but to give a brief example would be that
Please do.
in order for DRE3 to be supported, generally, basically, almost in all cases, there would have to be radiculopathy involved, that being things, problems with the extremity extending from those nerves in the spine to support that level of impairment. To have radiculopathy means you can be in DRE3. To not have it, or to not have ever had it,
Sure.
then you drop back into lesser DRE classes, and that's probably the most frequent situation we encounter when dealing with a spinal injury. There is the range of motion method also. The doctor opting to utilize that lesser preferred method when there are very set criteria in the AMA guides that would tell the doctor when it's appropriate to use that method. Some doctors will go to that method without necessarily narrating how the criteria has been met to use that method.
One thing that you pointed out was really interesting. Let's say you have DRE category 3 application. DRE category 3 off the top of your head, what's the impairment percentages on DRE category 3? Can you tell me the range? Anyone know off the top of their head?
Lumbar's 10 to 13%, and cervical, is it 15 to 18?
Fantastic, Alex. Thank you for that. You knew that off the top of your head. So let's say we're doing the hypothetical of 10 to 13%, right? Doctors often say, hey, it's 13%, which they'll often just give the highest percentage of that range, right? And they'll say automatically 13 applies. Well, you don't always have to accept the 13%. You can sometimes say, hey, doctor, they might be in DRE category 2 or 3. Why wouldn't they then be in the lower percentage of that whole range, right? So you can often shave off a few points just by doing your job, asking them about their findings. Hey, say the ADLs are maybe more extensive than what the doctor may address, and that's how you can kind of shave off a few points for the lumbar or the cervical. So I'm glad you pointed that out, David. Thank you for that. And Alex, what type of injuries in Europe that have you seen? What type of injury is most frequently given incorrect impairment by doctors?
I'm going to go with Dave's on that one. Spine, it happens all the time. As you mentioned, with the DRE categories, just automatically assigning the highest WPI allowable within the range. There's a specific sentence in the guides that state that range is specifically to account for continuation or resolution of symptoms and the impact on ADLs. And so a lot of times we'll see a very short ADL section of the report showing not too much impact, and then we'll see a high DRE finding, and those two things just don't align.
Sure.
The other thing we see a lot of times is highest DRE impairment classification and then an added pain add-on, and a lot of times we have to argue that's duplicative. There's all that increase already accounts for subjective pain and ADL limitations. So adding another 3% on, you've now effectively given 6% for subjective complaints. So we see that often. The other one that I see a lot is jumping to Chapter 13 for gait derangement for something specific to the lower extremities. And I would say that's probably one of the more frustrating ones because the guides specifically have a table in Chapter 17 that's specific to the lower extremities for gait impairment. So when an evaluator jumps to Chapter 13, it's a red flag for us.
Yeah, and the red flag wise, I think I think a lot of us are kind of nodding our heads across the board, including myself, because that's oftentimes when you see a doctor trying to probably give the most impairment possible, and if it's obvious that we see it it's not just us, it's also the judges that could see that. But that's fascinating what you just said, because I could think of like 6 cases where I have right now where the doctor did just that. So on the flip side, to be fair, now Alex, how often does a doctor, in your opinion, correctly state the whole person impairment in the reports that you review?
Mathematically correct, I would say probably 65 to 70% of the time.
Sure.
So actually mine's a bit lower than Dave's, but I would say mathematically correct. I don't have to make those changes as often. And there are several times where I get it. You've evaluated 15 different body parts and you've done range of motion for all of them. Something's bound to get lost along the way. But that's why it's so important to have a second set of eyes, third set of eyes, doing the calculations just to make sure everything's lining up.
Yeah. David, how about you? How often does a doctor correctly state the whole person impairment in the reports that you review?
I would say, yeah, I guess I would pretty much in about the same range as Alex. I mean, 2 out of 3, is in a good week, in a good week of rating reports, 2 out of 3. But it does, if things tend to trend about around 2 out of 3, I think. Uh, but I would just sort of append to that there is nothing from a rater standpoint that is better than a well-written report by a doctor,
Sure.
whether it is, well articulated, a doctor who's aware of how the guides are used and is also willing to narrate how the doctor used the guides to arrive at those numbers. Those are the ones that, whether the impairment be high or it be low, for the type of the injury, if the doctor has really done their work in articulating that impairment, it gives us it gives me assurance that the doctor's done their diligence, uh, shown their work. In many cases, in some cases, they will show their calculations all the way down the road to their conclusions, and those are a joy to address from a rater's perspective. Um, it's the ones where there are just questions unanswered, information not provided, leaps uh, from from physical findings to a number, but not explaining how they got through that process, how they got to that conclusion. Because there are branches between those that the start and the destination, and there are branches in the path that if we don't know which one the doctor chose, um, we have to call them out essentially on, that this is not effectively supported.
I think you're preaching to the choir here because the comp nerd in me gets really happy when I see a report properly apply the guides. And guess what? It's not just the defense attorney, but it's also the applicant attorney and the judge who are also happy by that because you know what? That means they're properly applying what the injury rates out to. So I can tell my client, hey, this doctor may have given a little higher than we may have thought, but guess what? It's properly applied and it's substantial medical evidence. And then the other side likes it too because then their client is given what's fair and what's adequate. And the AMA guides, if it's properly applied, is fair to the defense. It just is. Rarely do you go super crazy. It's things that go outside the AMA guides, outside the four corners, which we'll get to, that kind of can be problematic, which we'll get to as well. But no, I definitely appreciate your response. Thank you, David. Alex, what are the most complicated types of injuries to rate in your opinion?
Multiple body parts.
Sure, sure.
Sometimes we see, 15, 20 body parts. Honestly, I
Yeah.
didn't know there were that many. But you see them all, and you have
Right.
to go step by step through each of the rating methodologies to make sure that it was fair. Um, I would say those get pretty complicated.
Sure.
Um, I'm trying to think of what else, but I would say those require a lot of organization on our end, a lot of setting up the report and making sure that we're getting all of the information.
Sure. How about internal injuries? Are they deemed to be, do you think they're overall to be considered kind of more on the complicated side?
Absolutely.
Yeah.
Absolutely. Internal gets very complicated by non-industrial pre-existing conditions,
Oh yeah.
um, outside stressors outside of your employment, um, diabetes, high blood pressure, those things we see often. They're not typically considered industrial, though they can be aggravated by industrial stressors. But when you get into the nuances, the AMA guides do a really nice job of laying out this is the permanent disability or the impairment for orthopedic injuries. It's relatively straightforward. Once you get into those internal, here's a classification. It's 0 to 20%, and find a number in the middle of that makes sense. So there's a lot more subjectivity, a lot more reliance on the judgment of the examiner to make sure that that the number makes sense.
Sure. And I'm violently nodding my head in approval as far as the internal perspective. I think, and that's where the practice tip here is, when you have the internal, I think you mentioned something that's really important is oftentimes there's non-industrial pre-existing issues, diabetes, high blood pressure, hypertension, any type of hyper involved, you all know what it is, hyperlipidemia, et cetera. That's when the practice tip is you need to get the records, right? Go and subpoena the pre-existing or the non-industrial or the personal care physician records, because once you have that, you can really strive to make a big dent in the doctor's findings, whether it's causation or apportionment. There's often where there's smoke, there's fire, right? If someone's injured at work on an internal basis at your employer, guess what? Chances are they probably had something pre-existing. It's not just something that happened on the site, on the job. So you're definitely preaching to the choir. Thank you, Alex. David, how about you? What are the most complicated types of injuries to rate in your opinion, sir?
Well, I would build a bit on Alex's answer about multiple body parts. For some reason, I've had a recent trend of dealing with cumulative trauma injuries for professional athletes.
Okay.
You can only imagine in a cumulative trauma for, say, an NFL player, an NBA player, a Major League Baseball player, how many body parts might have been affected by the course of their career.
Sure.
And of course, they can often end up being what we used to use as a short-term head-to-toe claims. But within that, so addressing multiple body parts obviously has a great deal of complexity. It's laborious to work through each body part. And when we arrive at the end of the upper extremities, when we've worked our way from the shoulder to the elbow to the wrist, we have the hands. When a doctor assesses the hands and it deals with something like loss of motion in the fingers, now we are even within the hand, we could be addressing over a dozen a dozen conclusions on impairments for within the hand, for each finger, for each joint in each finger. So of course, interestingly, as your audience may know, I mean, there's, absent perhaps, let's say, an amputation of the hand and a really unfortunate injury, if it's simply a matter of some degree of functional limitation in the hand, those impairments don't add up to a great deal. But oddly enough, the work that it takes to arrive at those impairments is significant, more significant than any other body part when we're using the guides.
I think we could probably have another episode or two featuring just the hands alone, because they are such a complicated body part. And something that some of us have unfortunately dealt with is, if you have a hand injury, usually it's a carpal tunnel, which doesn't give the most impairment. It's relatively straightforward, right? Someone has carpal tunnel surgery, they may have bilateral. You're usually permanent stationary within a couple months and you're back to work. Great. But, and again, a big BUT is the fact that hands can get very complicated, as David, you pointed out, where some of us have seen a pinky crush injury turn into a hand body part, then the wrist, then the entire arm, then the entire extremity, then the entire bilateral upper extremity. So, yeah, complicated to say the least, for sure. And one thing both of you mentioned, which I think the multiple body parts, that's where it gets very dangerous, right? I think everyone listening in, including myself, has that 1 or 2 or 5 cases in their inventory where, not one body part is 80%, but you have, a pretty injured individual who's got a bunch of, 15% impairments. But once you stack those up, when you have 6 or 7 of those, then you're looking, unfortunately, in the 60, 80% range. So, yeah, those stacking about multiple body parts is really something that needs to come in. And that's where your analysis comes in, right? That's where we can sometimes say, hey, look, doctor, you're over applying pain for every body part. So then if you're really doing that improperly, if it's baked in already into the guides, that's how we can really start to chip away at the impairment. So all of a sudden we go from having a 75% PD rating. Then you chip away. Next thing you know, it's 50. And again, 50 is not low, but hey, it's better than life pension, right? So definitely appreciate both of your perspectives on that.
Have you ever had the pleasure of reading one or more of the hundreds of newsletter articles found in the B&B blog? If not, you are missing out on a tremendous tool. Every week, our attorneys demonstrate their special insights into the defense of workers' compensation matters. Individual articles are available on our B&B blog page at bradfordbarthel.com where you can also sign up to automatically receive new articles and upcoming webinar information.
So, Alex, give us a little brief overview of your career journey and how you arrived at your current role as a permanent disability rating specialist in the AMA Guides Analysis and Rating Department.
Sure. So I graduated from Sac State with a business degree in finance, risk management, and insurance. And I was working with a girl that I had just graduated with, and she walked over to my desk one day and said, "Hey, I just got hired on to this role in insurance, and they need one other person to round out their hiring group, and I need you to apply." And I said, "Okay." And I sent in my resume. And I think about an hour later, I got a phone call from the supervisor for the unit and had a very impromptu phone interview, followed by an in-person interview. And suddenly I was a claims trainee, and that's how I started. And I worked my way up to a supervisor position. And then I ended up leaving that company for a claims manager position to help start up a West region. So I definitely have that background in claims.
Huh.
And then I left that in mid to late 2024, and I joined Bradford and Barthel as a ratings expert. Just because it had always been my favorite part of claims handling is that
Interesting.
permanent disability review.
We appreciate that background. I think having that claims background is something that definitely helps kind of give meat to your analysis. So thank you for that.
Absolutely.
And David, can you please tell us about your overview and career journey and how you arrived at your current role as a
Sure.
rating specialist in the AMA Guides Analysis and Rating Department?
Sure. Your question reminds me, and for any 80s music fans, of the Talking Heads' Once in a Lifetime. There's a line that says, "You may ask yourself, well, how did I get here?" Uh, I have to say that my career in workers' compensation started back in the early 90s, and it happened somewhat accidentally. Um, I moved from the Midwest in 1987. I had a bachelor's degree in
Hmm.
literature from University of Iowa, the NCAA Women's Champions basketball team, just one. I landed a job with a firm in Century City as a file clerk in the bankruptcy division. It was a big corporate firm. And I took that job because I was a starving musician who wanted to be a rock star. Came out here from the Midwest, like many of my generation did, and needed a good day job, and it was great. It it had a balance with what I wanted to do, and gave me a little time. Gave me a paycheck. Then I left in '89, played full time music for 2 years on the road. Came back and when I came back, I took a file clerk job with a workers' compensation firm, and I honestly would say I don't think I knew about the realm of workers' compensation law before that. But as when I took that job, my boss saw a potential for me to do something more and put me through an MCLE training course, certification course for workers' compensation. I spent 14 Wednesday evenings learning about work comp from Commissioner Mark Kahn. Former Commissioner Mark Kahn from WCAB was the instructor. Took a rating took a rating seminar contained within that. Learned and really took to it as a skill. I went from that to my boss bought me 2 suits in Beverly Hills and said, "You know what? Now you're a hearing representative." And he sent me to court. I handled MSCs and anything less than a trial for years with his office. Then I transitioned to another firm doing similar duties, the hearing representative and the rater for police and safety officer cases. I transitioned from that firm to another firm and continued to do that. I've done thousands of
Hmm.
conferences, rated thousands of reports in the course of that. And then in 2024, I felt like I needed a change of course. And this is an example of how the universe will give you what you want if you ask. I was completing a mandatory settlement conference, and we're doing a post-conference wrap-up with Kimberly Wagner from Bradford and Barthel. And I very casually mentioned to her, I said, "Hey, if you know anyone who's hiring out there, I need a change." And
Interesting.
she audibly gasped. I will never forget. And she said, "I think I have a job for you." And then she proceeded to explain to me that Bradford and Barthel needed to fill a vacancy in the rating department. And I interviewed, and in November of 2024, I came over to Bradford and Barthel, and it really has truly been a life-changing opportunity to focus on honestly doing, yes, my favorite part of dealing with workers' compensation, rating permanent disability. And it's been a challenge, the right kind of challenge. It's a little stressful at times, but it's the right kind of stress. It's been a great ride so far.
Your input is greatly appreciated, both of you. Is there usually one way to rate an injury, or do you think ratings can be subject to interpretation?
I think unfortunately it's both.
Right.
When I started here, our colleague said there is no right way to rate a wrong report. A wrong report is always going to be wrong. And there's only so much we can do with it. So I often find that defense and applicants are trying to agree on a permanent disability value. And I would say maybe more important is agreeing on a whole person impairment. Because
Mm,
once you have an agreed whole person impairment, yes, there's the the permanent disability rating schedule gives you a very clear-cut method to arrive at a permanent disability figure. It's that whole person impairment that is oftentimes subjective and what is actually in dispute.
yeah, I love that. There's no, you can't properly rate an incorrect report. That's, I'm going to start writing that down when I see something. But I think the practice tip here is look, if you have a good impairment report, let's say hypothetically from a treating doctor that is from an orthopedic doctor, right? And if you, let's say you have a pain management or a not so preferred specialty of chiro as the panel QME, then what I do is I highlight the good report from my treating doctor to the QME, right? And it's oftentimes to give them a heads up, say, look, there's already been an evaluator who's addressed impairment, but also kind of keep everyone honest. Say, look, sure there might be the medical legal evaluator is supposed to put his or her spin on what they believe. That's fine. We need that. Everyone needs that. But guess what? There's already been a doctor who provided that. So I often keep doctors honest by making sure I highlight that. And the practice tip is put that in your cover letter, because once you do that, it really puts your client in the best position to maximize the likelihood of having a favorable reporting. Now, Alex, inquiring minds, including myself and our audience, we really want to know, how often do you see doctors applying legal theories like Kite and Almaraz Guzman to impairment opinions?
Correctly? Not often.
Okay, gotcha.
Incorrectly, often, often. I would
Okay.
say in recent months, years, I've seen Kite and Vigil very frequently, and it's something that I have to tackle each and every time because
Mm,
it often does not rise to the level of substantial medical evidence. Just using the word synergy isn't enough. I was reviewing a report and I had to send Dave a chat message because I was like, "Am I going crazy on this one?"
mm,
Because somehow we came to 100% loss of the hand through a Almaraz Guzman analogy, which maybe not fully supported, but I can maybe see how they got there, and then applying Kite to add the psychological impairment.
mm,
I was very confused. I couldn't figure out where the doctor was going. And if you've already lost 100% function of the hand, how is a psychological impairment amplifying that in any
mm.
way? You've already lost total use. And so it was a new way that I had to kind of tackle the subject because it's something that we're seeing more and more often, and I don't have a one-stop answer each and every time
Right.
for it.
Again, we could probably have another 3 episodes on misapplication of Kite and another 6 episodes of Almaraz Guzman. So I have a few follow-ups, but David, we'd love to hear your opinion as well. How often do you see doctors applying Kite and Almaraz Guzman to impairment opinions? And, what are your thoughts on whether these are actually applied correctly or incorrectly?
There seem to be trends. I will in some weeks of rating reports not see anybody to bring up
Hmm,
Almaraz Guzman, not
hmm,
see any doctor bring up Kite or the Kite Vigil decisions, and then suddenly have 5 in a row. 5 in a row, with Kite Vigil asserted. So it's actually hard for me to give a number on how often we see them. I would say that if we take those as a whole set, those Almaraz, Guzman, and Kite and Vigil, that I would see one or the other
Hmm.
in about every fourth or fifth report that crosses my
Okay.
desk. We always have to look out for them. We always have to see because sometimes the doctors will not be especially they won't put it out front there that they're asserting Kite Vigil or Almaraz Guzman. Kite Vigil in particular, often that can be tucked in somewhere in the report without a great deal of without highlighting, without its own section, without they'll invoke the cases. They'll mention the names, but they won't extend into explaining, which Vigil essentially requires them to do. They won't venture into explaining. Now, here's why I think this applies. Vigil in particular established very set criteria that was sadly lacking going back to the Kite decision. It was really more sort of ethereal at that point, whether or how it could be applied, the adding rather than combining. But Vigil really helped us. It's the decision I go directly to in an
Sure.
instance where the doctor is invoking, I want to add instead of combine, to say, okay, well, have you explained how it conforms to what the WCAB would expect for that to be to override or rebut the combined value approach in the rating schedule. Alex and I were talking earlier, and I think I like what she had to say about synergy or synergistic effect, just being often the doctor's rationale seeming to rely on that, and by simply stopping at using that term or that phrase, thinking or I guess assuming, well, my work is done here. I've said synergistic effect, so that's it. That takes care of my of the responsibility to support adding instead of combining. You asked how often they're supported, I
Sure.
believe. With regard to Kite and Vigil, I would have to say, in my experience, 20% of the time.
Wow.
I was going to go lower. I was going to say 1 in 10. I was going to say 10%.
Yeah.
Yeah, it's a tricky area. You mentioned, trends and, I think synergy is a word that we've used in the last 10 years more than ever before in the history of human civilization. And synergy, comes directly from Kite and Vigil and that whole universe. But as far as trends go, let's say the last, 1 or 2 years, what are some trends you've seen that doctors are trying to incorporate when they do apply Kite specifically? Alex, anything you've seen of late that doctors are trying to squeeze in?
Specific to Kite, I originally used to see it just specifically with bilateral extremities.
Okay.
So right arm, left arm, okay, add 'em. I don't always agree with it, but I can understand the justification there. I am seeing it more and more often with completely separate specialties.
Mm,
So now I've got an
gotcha.
orthopedic doctor saying, nope, these orthopedic impairments should be added to the internal and the
Ugh.
psychological impairments as opposed to combined. So that's something new that I'm seeing. Um, and I'm also seeing, I think David touched on it. There is no rationale, but they've also not thought through how we're supposed to apply these things. They'll say, the cervical needs to be combined with the shoulder, but then we need to add in the knee. And it doesn't make sense in terms of the rating schedule and just how we're supposed to rate things.
Uh-huh.
So again, it takes me back to you can't correctly rate a wrong report. Sometimes I just have to say, I don't know what the doctor
Right, right,
intended here.
right. I think sometimes when a report is a little too good, you got to tell your client, hey, this might be a little too good for us to kind of really, really take to trial or really get the other side to accept. But sometimes a report is, so bad that it's good. What do I mean by that? Is what you mentioned, Alex. When a doctor is applying Kite or misapplying Kite, when they're trying to add the shoulder, to the ankle, you gotta kind of say, hey, look, Kite was designed around the hip and the hip, both hips, bilateral hips, right? One hip added to the other. Do I agree with it? No. Does it kind of make sense? Yeah, a little bit. And in that realm, right? Both hips there is a synergy, there is a synergistic component. But sometimes when you're like you mentioned, if the doctor's trying to apply Kite to completely opposite body parts, then that's so bad that it's good because it's not going to. You got to really challenge that and kind of make sure that you stay aggressive with cross-examining the doctor, making sure you point that out to the judge. So I'm glad you pointed that out, Alex. How about you, David? Any trends that you're seeing of late, the last 1 or 2 years, as far as Kite or Vigil beyond what you've already kindly mentioned?
I think my answer honestly would be parallel to Alex's. Yeah,
Gotcha.
that venturing. I mean, there's definitely been more venturing into different regions of the body or
Sure.
different conditions, uh, uh, superimposed or linked with other parts of the body or other regions, and saying this is this amplifies or this does not overlap. They're being more, I guess, creative in their assertion of Kite. And it all goes back again to, well, explain how you think, why
Right.
you feel that way. Explain why you think that's the case. Uh, the doctor who um, uh, does diligent work in explaining that is pushing the probability of a trier of fact to accept that theory, that conclusion. A doctor who doesn't do much in the way of explaining or providing rationale um, would be, as I think you phrased it, simply a good bad report in terms of from a defense perspective.
Sure.
If the doctor isn't delivering ample support and that can be explained to a trier of fact to be reminded of the criteria that are necessary, particularly under Vigil, uh, there's a very good probability of success in having the trier of fact give disregard to the assertion of Kite and go with the
Fair.
standard of combining the values of the permanent disability as per the schedule.
Fair. I think you brought up something that is the report still has to be substantial medical evidence. So you can't have an orthopedic doctor try and use Kite to internal medicine or a psych injury as well. The orthopedic doctor is limited to their opinion on the orthopedic body part. So that's often something that automatically should get struck by the defense on that one. So, David, can you tell us what is your favorite type of injury to rate?
My favorite type of report to rate is a well written report by an orthopedic doctor who looks at each condition, whether it be one or multiple body parts, and goes to the most logical method of assessment that the guides would state to be preferred or just explicitly identified for those particular limitations that were witnessed in the physical examination, and uses the guides by the letter sensibly and explains their calculations. Um, Particular type of injury.
So many, right?
Oh, there are so many.
Where do you start?
um, I think that the most common ones are the ones again the spine region. Uh, I would have to say that would be my favorite because I feel that I have
Mm.
the most absolute degree of either certainty in my conclusions based on what the physical findings are, or that I feel a high probability of that I've gotten it correct based on what the findings are. And that may be independent of the doctor's opinion.
Sure.
That may be that I can confirm or verify the doctor's correct based on the physical findings, or it may be such that I can effectively rebut what the doctor is saying, that, well, this is what the physical findings say, and I'm certain, based on my interpretation of the guidelines, that the impairment to be assigned is actually something different than what the doctor gave.
Appreciate it. And Alex, can you tell us some misconceptions about your line of work as a permanent disability rating specialist?
Sure. I think there's this misconception that because we work for a defense firm, we're always going to try and argue for 0% permanent disability,
Mm,
or the lower the better. And while that's certainly something that we can help our defense attorneys and our adjusters with, at the end of the day, what you really want from us is objectivity. You want us to read the report
sure.
and say whether this impairment is supported or not. Because if we go in and read a report that is supported and we tell you otherwise just so that you can get a lower impairment, that's not going to make anybody look good.
Right.
So at the end of the day, that's we're objective. We're reading the objective findings, the medical history, and we're telling you, yes, this is consistent with the AMA guides, or no, it is not. And that's, I think that's ultimately what we're best at.
That makes a lot of sense. No, thank you for that. Now, David, if you could make one change to the 2005 rating schedule, what would it be and why?
Well, it's been, the 2005 is our most recent schedule, and it is
Yeah.
now old enough to vote, old enough to drink, old it's
21.
21.
Okay.
Yeah,
There we go.
it's been around a long time, and the schedules that preceded it, in my experience, they were doled out in there were those were at points in time further back as well. With each of these schedules, going back to the first one I used in 1987, uh, they give us the job titles and give us an occupational variant or group number
Mm,
by which to as a variable to determine the impairment. If you were to go back to the schedule from the late 1980s, you would find jobs as archaic listed as egg candler, one who holds up eggs to look at them to make sure that the egg is whether it goes in the fertilized or unfertilized down at
You
the
don't have your
farm.
own egg handler? I thought we all have our own
Yeah,
personalized egg handlers.
and, telephone operators, cable splicers, people
Yeah,
putting phone. Remember landline telephones, everybody?
what are those? What
Uh,
are those?
yeah, people that were doing those jobs, and of course, at that time, that point in time, some of those
Mm,
occupations were very common, where others were, early 20th century, and really didn't have any place in the schedule anymore. The 2005 schedule did a fairly good job of giving us accurate or appropriate group numbers for in terms of arduousness of the job, the type of the job, and how various parts of the body were affected. And it gives us those quite specifically for lots of things that are relevant occupations these days. But but it's been 21 years, and
right.
the nature even of a job defined in 2005 under a certain group number may be more hand intensive now in that title than it was then.
Sure.
May not involve as much driving. You know, we've got radical changes in how we travel, how often we need to travel, how often we are working in an office or working out in the field or working from home. And those group numbers may not
Mm,
necessarily correlate now to the realities of injuries that are suffered in the mid 2020s. There's also, it would be ideal also if some titles that either didn't exist or what weren't considered in the 2005 schedule would be updated. If there were an updated schedule, that there would be um, reclassifications, assignment of introduction of occupations that may not have been so common back then. I think the variant of the occupational group number is so important to our conclusions on the permanent disability that I would start there with a new schedule.
I think the old schedule used to have the occupation of horse buggy operator, so we don't see that too much more in 2026, 2027, but, how
You
about you,
might in
Alex?
downtown Sacramento. We still
Well,
have horse buggy operators in Old Town.
my apologies to the, horse buggy operators in the 916-530 area. My apologies to you all. Deep apologies for our deep audience. But, Alex, how about you? If you could make one change to the 2005 rating schedule, what would it be and why?
I have to tag off of David again.
Yeah.
Some of the variants, the occupational variants that we see just don't necessarily make sense for this day and age. The one that I can think of specifically is emergency medical technicians. The psychological variant for EMTs is low. It's an E, which is it's very low. And you would think as an EMT, you're probably seeing some things, and you'd want to be psychologically sound for that. So it always surprises me just how some occupations have a variant that doesn't make sense to me.
Yeah, both of you pointed out something interesting about occupational variance, and that's where oftentimes when a permanent stationary report comes out, and let's say that the defense and the applicant both agree with the doctor's rating, the doctor's impairment or apportionment, whatever. The reason why the ratings don't match often is because the occupational variant is different, right? And that's where oftentimes it's off by 2 or 3 percentage points because we want to provide a more conservative rating and variant than the applicant who wants a more liberal or applicant friendly rating. But that's where you really should, from a practice tip perspective, get the personnel file, be upfront and kind of understand what types of job duties the applicant has been dealing with. Ask at that position so you can try and get the most conservative or applicant or defense friendly occupational rating, or even just getting the most accurate rating, right? We don't always want to be the most defense friendly. You just really want to get the most accurate, because if you're accurate, then we can all live with that, right? Whether you're applicant or you're defendant. So super appreciative answer. You both have been amazing. Thank you for joining us and giving your perspective on the AMA guides analysis and rating department overview. Alex, can you briefly tell us how a claims examiner or anyone out there can send a report to our department to get rated?
Sure. I'd say there's two primary methods. You can go to bradfordbarthel.com, and I believe there's a button in the right upper corner for refer a rating. That's going to give you the referral form to make sure that we get all of the information necessary. And I believe it also gives you a section to upload all of the reports. And that comes directly to us and gets dispersed to whichever rater is available at the time. You're also welcome to email our ratings at Bradford Barthel email address. And the primary things we want on that is telling us what report type you want. There's different levels that we can do, whether you want just a strict review of the doctor's report with any corrections. But then that also goes all the way up to a full analysis, which is when we're doing that deep dive into whether objective findings support the impairment. So we've got multi-tiers that you can choose from there. And just making sure that we've got an occupation and job duties if that occupation is vague. But you can always email us at that ratings at bradfordbarthel.com or go to the Bradford Barthel website and refer it directly online.
Thank you very much. And that email will be in the show notes below as well. So thank you both again, David. Thank you, Alex. You've been awesome on joining us on Comp Corner. We'd love to have you back someday as well.
Thanks for
We'd
having
love
us.
to be back.
That wraps up another episode. Big Comp Corner thank yous to Alex and David for sharing their expertise and giving us a glimpse into the wonderful world of disability ratings, where a sharp eye, a calculator, and a healthy dose of skepticism can make all the difference. As always, thanks for listening. Be sure to subscribe and join us next time as we continue exploring the strategies, challenges, and nuances that shape our workers' compensation system. See you all next time on Comp Corner.